Now we briefly review the part of Chapter 4 we've already gone through, our introduction to negligence. It begins with a history of negligence. For our purposes, I do think it's useful to note that everything that's currently actionable as negligence previously was actionable as other differently labeled causes of action. For example, negligent battery, as opposed to intentional. We also saw that from the very beginning, certain professions were held to a higher standard of care than others, those relating to hospitality and transportation in particular. We were introduced to the elements of the negligence cause of action: duty, breach, causation, and damages. We see that damages really are an essential element of negligence. Absent real damages, a negligence cause of action does not lie. And that's an important thing to keep in mind, because for intentional torts, minimal harm is good enough to establish the cause of action, because the defendant's state of mind is tortious. In negligence, the defendant's state of mind is oblivious, not doing things deliberately wrong. Now, down the road, we're going to be studying recklessness and things that are more than mere negligence. But for our purposes right now, we're focusing on the basic elements of negligence and then a formula for analyzing. Now, I suggested that for our purposes, intellectually, it's useful to add an additional element to negligence intellectually, and that is defenses. Now, obviously, defenses are not part of negligence. The plaintiff doesn't have to show defenses, right? Only duty, breach, causation, and damages. But analytically, I always include defenses as the last step of negligence, just to make sure I think about it. So that is an eccentricity of mine that I share with you and will now leave. Next in negligence, we considered a formula for negligence, and we looked at both actions and failures to act as negligence. In Lubbock versus Wells, we looked at the golf club case, where the plaintiff is injured by a kid swinging a golf club, sues the other kid and sues the dad, and the court says the dad is not subject to liability because it's not really foreseeable. The golf club is not so intrinsically dangerous as to put the dad on the hook. That phrase, intrinsically dangerous, comes from the case. Now, if the dad had left a loaded shotgun in the backyard, almost certainly a different result, because a loaded shotgun is inherently dangerous, and kids naturally point and fire toy weapons at each other. It would be no big surprise if a kid did that with a real weapon. In the Blythe versus Birmingham case from 1856, we see an ancient water main break. It seems in LA, basically every other day one of these water mains is breaking. But what's different is that in the LA cases in 2014, those water mains are breaking because they're 130 years old and no one's touched them. They need to be replaced, and they're breaking. But in the Blythe case, what was different was that the frost that froze the pipe was really without precedent. And so the design and implementation of the waterworks was appropriate. The defense argued that they acted reasonably, and the court agreed. And then finally, we touched on Pfeiffer versus Parcell. That's the case with the three teenagers in a car. Every time I read this case with my almost 16-year-old daughter, I think we're going to get her a Gremlin that will only go about 20 miles an hour downhill. But we get a good breach of duty analysis at page 139, and we see that the adult standard of care is applied to a child doing adult things. Now, we're going to look at a number of kids doing grown-up stuff cases today, and I think also next week. And we'll see that, by and large, children are held to an adult standard of care. Perhaps it's not always entirely reasonable, but that does appear to be the way the law goes, and there isn't a huge amount of debate about it. I like all of the notes after the case at page 140 and 141. I don't have anything new to say about them, but I did close last week at page 141 looking at the case of Rowland versus Log Cabin, where a bartender is facing liability for allowing a great big strange dog nobody knew to roam around this bar and then finally chomp on somebody. That was found to be, actually, it doesn't look good for the defendant. As I recall, their liability does flow from that. And so, with all of that in mind, what we are focusing on right now as we get into the new material is a negligence formula. What we're doing here is we're working with the different elements to see how they fit together and how they function. That brings us to the Chicago B&QR Company versus Cranville case, another really old case, over 100 years old, but it gives us a good chance to focus on a formula for negligence. So let's begin with Mr. Corbin. What basically happened in the case? What did the kid do to hurt himself? Chicago Railroad versus Cranville, page 141. Right, turntable to rotate a train. What specifically did the railroad company fail to do that they usually did? Uh-huh. Well, basically, I think what happened was it was revealed that they got lazy, and they sort of routinely left this unpadlocked. And was the child plaintiff lawfully on the territory? Correct. This is another trespasser case. You're a child trespasser, and what injury does the child end up sustaining? Right, so the kid lost a foot, a very serious injury. Now, if you look at page 142, some of the very first stuff that the judge writes, there is a part of a formula for negligence that's well worth our paying attention to. What's going on here at page 142 is the court is balancing the utility of the conduct against the harm. Everybody knows that trains are dangerous. And if you read the cases, they were extraordinarily dangerous early on, and now modernly somewhat less so. Now, compare this railroad case, again on page 142, to an open well. And here, an open well is obviously dangerous to children, even uninvited trespassers. And making it safe isn't very expensive. The danger, very great. And so we see that the purpose of this case is to establish this idea of balancing the utility of the conduct with the harm. Railroads, hugely important, very valuable, also quite dangerous. A privately owned well, valuable to the owner, not terribly important to the public, the life of children, highly important. Now, a doctrine suggested by this case that wasn't actually used, I'll write it here. Attractive nuisance. Now this phrase actually is a little bit deceptive when you think about it. The word nuisance is a tort theory of liability. We haven't gotten into it yet, but we've touched on it a couple of times. A nuisance is a situation where the defendant has engaged in conduct that makes the plaintiff's land less enjoyable to the plaintiff. So if the plaintiff is on parcel A and the defendant is on parcel B, and the defendant on parcel B is having loud drug parties every night until 4 in the morning with a blasting stereo, that's a nuisance because it hurts the plaintiff's property. But here with an attractive nuisance, we're only looking at the defendant. We're not looking at the plaintiff's property at all. So this open well that's referred to, or in a modern condominium complex, a swimming pool. You know, every condo in America basically has a big fence around the swimming pool and a locked door. And the reason is because even kids who can't swim are attracted to pools, especially on days like this. It was 103 when I arrived at the school this afternoon. So an attractive nuisance is something that puts a burden on a landowner or land occupier to make the property safe even to uninvited trespassers. So this discussion on page 142, balancing the utility versus the harm and comparing a railroad to an open well, is getting at this attractive nuisance doctrine, even though the court doesn't actually use that phrase. Look at the note 2, at page 143. Here we've got a situation where the defendant who's doing construction work on a highway set out a flare pot to give warning and then left it out in the street until way after daybreak. And a kid meddles with the flare pot and is seriously burned. Okay, should the defendant be liable in that case? What do you think? Anybody think not? Well, I'd suggest liability would be likely because the utility of having a flare pot in daylight is basically zero. It's basically only dangerous once the sun comes up, and the burn suffered by this kid was unnecessary. There's really no social good brought from that. Okay, the next case is the Davison case at page 143. Dr. Dudoué, not present tonight, so she escapes her chance to be questioned. But I know she's watching, so she knows that I'll be getting to her probably first next week. That, no doubt, will delight her. So, Mr. Hazinski, I turn to you instead, going in chronological order. What was the plaintiff angry about and suing Snohomish County in Washington? Yeah, and I think what's interesting, one of the things interesting about this case is that the plaintiff wins a trial and loses on appeal. What went wrong? Why did the plaintiff lose on appeal? Yeah, you're very much... Look at the date of the case, though, 1928. People had not been driving cars for that long, and municipalities had not been building infrastructure for cars for that long. Looking at the last full paragraph before the judgment is reversed, I read that paragraph as basically amounting to the court finding that the defendant municipality built this access ramp to the bridge as well as they could under the circumstances at the time. Is that how you read it? I think that's right. And they're also, I think, arguing that the utility of everybody being able to drive on this bridge is more important than the occasional car that drops off and falls to the ground. But take a look at what happened 40 years later in the 1968 case mentioned in Note 1. That's Bartlett versus Northern Pacific Railroad Company. The facts are identical, and the court explains that engineering has evolved substantially in 40 years. And I'd suggest also that the expectation of drivers has evolved quite a bit during those 40 years too. So from 1928, where there's just Tin Lizzies on the street that have every driver is novice and all the infrastructure fairly new, or retrofitted to allow cars in addition to carriages, that as the technology improves, so does the standard of care. It has to be better as the technology improves. Now, take a look at note 2 at page 145. Here we've got a train track which is placed really close to the highway. An 1882 case. The train goes by while someone's riding a horse, and the horse is frightened. Should there be liability there? Again, I think it would relate to foreseeability. Now, look at note 3. Now, here's a question I don't really have an answer for. I do have an answer, actually, but I'm going to keep it to myself for a moment. So let's consider this hypothetical. In determining whether a choice of alternatives is reasonable, must the risk of harm to third persons be taken into account? So we've got a train driver operating a train apparently reasonably, unexpectedly finds a truckload of furniture on a crossing ahead of him. He can stop the train abruptly and avoid the collision, but if he does, he's going to hurt his passengers. What should he do? Anybody have an opinion? What?
Go right through.
Why?
I think that's policy because...
Give me a good legal reason based on negligence, because there is one.
Okay. I would say that the probability of harm to the passengers on the train outweighs
You're very much on the right track. Spit it out.
the possible harm to passengers could be a lot worse than on.
That's a good start. Your thought? That's a little closer to what I'm looking for. Yes. That's an interesting idea. But does that affect the train drivers? Yeah, I think that's right. What are your thoughts? I can see you're paying attention. Have any ideas? Yeah. Ah, that's excellent. But that's a couple chapters away. But right, the idea that, yeah, that's also a good argument. Okay, you basically touched on everything, but one phrase. Go ahead. Very good. That's another angle based on the material we're looking at today. Now, the one phrase that none of you spoke that I was looking for was the phrase common carrier. This guy is a conductor or train driver driving passengers. The train company is a common carrier. They owe a higher than ordinary standard of care to their passengers. So the idea that the conflicting duties break in favor of protecting the passengers strikes me as being the most logical approach to this. And so I basically would agree that the train should just destroy the furniture. And you know what? Now, okay, let's say they do. The train goes straight through, smashes up this furniture. Is the railroad company liable at all? Why? What do they do wrong? Really? If they had a duty to keep the tracks clear, let's suppose that the tracks are close to, are on property owned by the rail company and maintained by them, and their failure to keep the tracks clear is a breach of duty. If all that's true, then they could potentially face liability to the truck owner, even if the furniture mover wasn't acting entirely legally. But otherwise, if I'm the defense lawyer for the train company, I put the furniture guy on the stand and say, don't you know it's dangerous to park on railroad tracks? What did you expect? And maybe the owner of the furniture moving guy would have some justification or some defense. Maybe there would be some reason that placed him on the tracks without any misconduct or contributory or comparative fault of his own. But the narrow answer that I was looking for here related both to the common carrier higher standard of care owed to passengers and also the idea of the utility of a train being more valuable than the value of the furniture that was on the track. But certainly I think we can all see that this is a fairly harsh choice that the driver of the train faces, and he doesn't have much time to make the decision either. Now, if we change the facts a little bit so that the train is going faster than it should be going, then the train company is going to be liable no matter what, because they're damned if they do, damned if they don't, because of their own employees' conduct. And there are lots of train cases about train going 40% faster than it's supposed to, etc. That's right. Remember that case in LA where the conductor's playing games on his phone or texting his kids or something and smashes up? And so one of the results of that, if I remember correctly, was cameras in the trains that are photographing the conductors to make sure that to keep a good record. Okay, next we reach United States versus Carroll Towing Company, another of these barge cases. Mr. Kalukakui, we turn to you. What was going on in this case? What did the trial court do with regard to damages in the case? Right. They basically divided the damages, and we're going to see how fault can be allocated later on. Now, this judge this very famous and distinguished judge with the very amusing name, Learned Hand, writes a decision on the case. How did Judge Hand solve this problem? What was the final holding in the case? Mm-hmm. Right. So basically, did the judge say that the barge tending guy was gone too long? Yeah, and that's too long. So ultimately, the narrow holding in the case at the very end was that the barge people should have had a bargee, a guy running the barge, on board during working hours and daylight. So, go ahead. I kind of got that impression too, and I sort of smiled at it as well, saying, well, guys, you got to be in charge of your own stuff. But I looked at that formula, and I have to tell you, I kind of smiled, because we lawyers are fond of math. Not really. But we want to use math to make it look like our thinking is valid. Now, if you take a look at the first note at page 147, I read that note as basically saying, look, the formula is a fantasy. It's not math. We can't escape doing the fairly comprehensive and very detailed factual analysis in order to arrive at a conclusion. Now, if you take a look at the note 3 at the bottom of 147 and the top of 148, again, we see an idea that relates to the facts rather than the law. The basic idea, as I read it, is the duty goes up along with the risk. The higher the risk, the greater the degree of duty. And it strikes me again that this is very rational. There's nothing counterintuitive in this material as I see it. Then we turn to note 4. Here is a classic balancing the utility versus the harm. Defendant is stringing high-tension wires and doesn't use insulated wires. Guy using a metal ladder ends up touching the wire, gets killed. The defendant basically says, well, look, it'd be really expensive if we had to use insulated wire. And the court says, well, cheaper than the value of a life, and liability is established. Now take a look at note 5. Here's a slip and fall case at a TSA airport security. Here, the defendant wins because they find there's no duty to put extra chairs for people to change their clothes. Not long ago, I had to make an air flight with my family. I was really bent out of shape. I said, folks, we may make the newspapers today because I am not going to take any extra abuse today. And if you guys take extra abuse, I'm not going to stand for it. We show up at the San Diego airport, and it's as if I had magically turned into Moses. Every one of those guys looks at me like a friend. It just welcomes me through. I don't even get patted down. They don't even scan me. It's like I'm a pilot or something. And I walk all the way through, and I'm kicking back with a drink in the lounge. 10 minutes later, my wife and kids show up, and they're like, you were going to stand up for us. And I said, well, I can't do that if they send me to the bar all the way through. So the TSA is resulting in all sorts of inconvenience and some fairly sloppy law also. Now take a look at the restatement of torts. We'll wrap up this section and then stop this video and get on to the next section dealing with the standard of care. But if you look at the restatement second of torts, realize there's been 2 more restatements since then, but this hasn't really changed. We see this balancing the utility versus the risk, and we see a number of factors at the very top of page 149 that are used to determine the utility of the actor's conduct, and then factors about the magnitude of risk. Now, these are all being introduced not so that you instantly memorize them and can call them up like that, but so that you understand these dynamics, so when you are placed in a situation to examine facts, you have some mental skills about how to do it. And of course, in the real world of practicing law, you get to look it all up. It isn't like on an exam where you have to sort of know it. Take a look at the restatement third, which begins at page 149, focusing on liability for physical and emotional harm. Here, we see that foreseeability is really an element that we have to consider. And also at the top of 150, the phrase proximate cause is slowly fading out to be replaced with something called scope of liability. Personally, I will stick with proximate cause. That wraps up this section. I will stop this recording, and when we come back, we will get into the standard of care.